Good afternoon to everyone on the East Coast and good morning to everyone on the West Coast. Thank you for joining us for our first quarterly webinar. This is Marty DeZor of DeZor Compliance Consulting. I serve as CCO for the IMST and IMST2 Trust. This is our first webinar. We'll be holding webinars going forward as a joint effort between FMAC, UMB Fund Services, Tate Weller, and DeZor Compliance Consulting. We are planning on having these webinars on a quarterly basis going forward, and we'll be covering topics each quarter. These topics are from a questionnaire you, the advisor, have completed in the fall of 2016. I'll be starting off today's webinar, which will be primarily covering Rule 17A7 of the Investment Company Act of 1940 and affiliated transactions. We also briefly go over Rules 10F3 and 17E1. Our panelists today are Diane Drake. Some of you may not know her. Diane serves as Secretary of the IMST and IMST2 Trust, and also is Senior Legal Counsel for FMAC. Joy Ostley, Vice President and Assistant Secretary of IMST and IMST2, and also is Co-Chief Executive Officer of FMAC. And Sir Jono of Kidman, Assistant Treasurer of IMST2 and Vice President of FMAC. If you have any questions throughout the webinar, please type them in the questions box on the webinar control panel. If you cannot see your control panel, click on the red arrow on the right of your screen to bring up the panel. The panelists will answer your questions at the end of the presentation. If we do not get to your questions during the webinar, we will contact you separately. Please keep in mind that questions pertaining to each of the Rules 17A7, 10F3, and 17E1 are included in the quarterly board book checklist. So we are hopeful that the information provided in this webinar will help you understand those questions and respond accordingly when you are completing those checklists each quarter. To begin, Diane Drake will be providing details on Rule 17A7 of the 40 Act. Thank you. Diane?
Thank you, Marty. Now I'm going to discuss Section 17A and Rule 17A7 transactions. Section 17A of the 1940 Act was designed to prohibit self-dealing and other forms of overreaching by an affiliate of an investment company, especially in situations where the affiliate has the ability and monetary incentive to influence the actions of the investment company. Generally, Section 17A provides that it is unlawful for any affiliated person of a registered investment company, which I'll refer to as a RIC, acting as a principal, to 1, knowingly sell any security or other property to such RIC. 2, purchase any security from such RIC. 3, borrow money or other property from such RIC. And 4, loan money or other property to such RIC. Section 17 provides, however, a person may file with the SEC an application for an order exempting a proposed transaction, which establishes that the terms of the transaction, including consideration to be paid or received, are reasonable and fair and do not involve overreaching on the part of any person concerned, that the proposed transaction is consistent with the policy of the RIC, and the proposed transaction is consistent with the general purposes of Section 17, which is to prevent overreaching by an affiliate. Rule 17A7 of the 1940 Act exempts investment companies from the prohibitions of Section 17A. Rule 17A7 exempts from the prohibitions of Section 17A1 and 17A2 a purchase or sale transaction between 2 RICs or a RIC and a person that is an affiliated person of such RIC solely by reason of having a common investment advisor or investment advisors that are affiliated persons of each other, common directors, or common officers. I've mentioned the words affiliated persons, so exactly who is an affiliate of a 1940 Act fund? An affiliated person is defined in Section 2A3 of the 1940 Act as anyone holding 5% of the fund's voting shares, an entity that has 5% or more of its voting shares owned by the fund, directors, officers, or employees of the fund, any person or entity controlled by, or under common control with the fund, and holding 25% or more of the voting shares of an entity is presumed to be control under the 1940 Act. And if the fund is a 1940 Act, any investment advisor or sub-advisor of the fund is deemed to be an affiliated person. On this next slide, we show a simple illustration of affiliated persons. A fund might be deemed to be an affiliated person of any other fund with which it is under common control. For example, a mutual fund having the same advisor, officers, or directors. So in this slide, we show ABC Advisor is the investment advisor to three separate RICs. There's the AAA fund, BBB fund, and CCC fund. So the AAA fund would be considered a first-tier affiliate with the BBB and CCC. Now, the AAA fund also has a sub-advisor, and as such, the sub-advisor is a second-tier affiliate of the BBB and the CCC fund. As an advisor, a sub-advisor is a second-tier affiliate of any fund under common control with the fund it advises, including any fund that is advised by a different unaffiliated sub-advisor. The SEC adopted Rule 17a-7 in 1966 to permit cross-trading between funds having a common advisor, and it expanded it in 1981 to, among other things, permit trades between different series of one investment company and trades with other clients of the investment advisor, such as separate accounts and hedge funds. Rule 17a-7 is available for transactions in both debt and equity securities. Rule 17a-7 contains a number of conditions designed to limit the permitted trades to those the SEC believed would be unlikely to be disadvantaged by the transaction. Although the rule contains a number of requirements, it is silent with regard to an investment advisor's fiduciary duties in connection with a Rule 17a-7 transaction. In a no-action letter issued by the SEC staff clarified that before entering into a Rule 17a-7 transaction, the advisor has a duty to, among other things, carefully consider its duties, the duty of loyalty, and its duty for best execution with respect to each fund. With regard to best execution, the SEC stated that an advisor should ensure that the selling fund's total proceeds are the most favorable under the circumstances, and the buying fund's total cost is the most favorable under the circumstances. In that regard, the advisor should consider whether the selling fund can obtain an increase in proceeds by selling the security in the market, and conversely, whether the buying fund can obtain a better price for a security by purchasing it in the market. With respect to Rule 17a-7 transactions being in the best interest of both the selling and buying funds, according to the SEC staff, that means that one or other of the funds cannot participate in the transaction if the transaction only benefits one of the funds. The SEC staff is concerned that if the buying fund participates in such a transaction, it may be foregoing an opportunity to make a better investment in a different security in the marketplace. The SEC's guidance could be interpreted to mean that if the transaction is in the best interest of one fund, but is otherwise neutral to the other fund, the fund for which the transaction is neutral cannot participate in the transaction. So what are the conditions of Rule 17a-7? First, the transaction must be in the best interest of each fund, and the transaction must be consistent with the investment policies of the fund. The transaction must be a purchase or sale for no consideration other than cash payment against prompt delivery of a security. The trade must be effected at the current market price, which is defined as the average of the highest current independent bid and lowest current independent offer determined on a basis of reasonable inquiry. No brokerage commission, fee, or other remuneration may be paid in connection with the transaction, except customary transfer fees. The investment company is required to keep records of all terms of the Rule 17a-7 transactions, And in addition, board oversight of the transaction is required, and the board must satisfy the fund governance standards of the 1940 Act. Internal cross-trades can benefit clients because the practice enables a manager to move securities among client accounts without having to expose the security to the market, thereby saving transaction and market costs that would otherwise be paid to executing broker-dealers. However, these transactions also pose substantial risks to clients due to the inherent conflict of interest for the advisor, which has a fiduciary duty of loyalty to its clients and also must seek to obtain best execution for both buying and selling clients. Most often we hear the terms principal cross-trades and agency cross-trades. So what's the difference? A principal cross-trade is one where the advisor trades from its own account and sells to or buys from the client from its own inventory. An agency cross-transaction for an advisory client means a transaction in which a person acts as an investment advisor in relation to a transaction in which such investment advisor acts as a broker for both the advisory client and for another person on the other side of the transaction. In this next slide, we show a very simple illustration of a cross-trade. So here we have mutual fund A and looking to sell a particular security, and mutual fund B intending to purchase the same security. As noted earlier, it is important that the security involved be consistent with the investment policies of each fund participating in the transaction, and this is particularly important if any illiquid securities are involved. Next, so I mentioned earlier, the 17A7 cross-transaction, no fee can be paid other than a customary transfer fee. So what is a customary transfer fee? It is not defined in the 1940 Act or by the SEC, but the conservative practice is to use the fee the custodian charges for simply moving the security off the books on the selling fund and moving it onto the books of the buying fund. What is the SEC's view on cross-trades? The SEC's view on cross-trades is that an advisor engages in a cross-trade when it intentionally trades a security between client accounts, regardless whether a broker-dealer is used. The use of a broker-dealer to effect a transaction between one of the advisor's clients and a RIC advised by the advisor is a prohibited transaction under Section 17A, and therefore the cross-transaction must be effected in accordance with the requirements set forth in Rule 17A7. Next, I'm going to talk about a recent enforcement action against Western Asset Management. In 2004, the SEC brought an enforcement action against Western for causing the funds to engage in improper cross-trades. Throughout the financial crisis, as Western's clients demanded account liquidations and as rating agency downgrades caused certain securities to be ineligible for certain of its client accounts, Western was required to sell non-agency mortgage-backed securities and similar assets in a sharply declining market. Believing these securities represented good long-term investments for other clients, Western frequently sought to repurchase for those other clients the same securities it was required to sell. In its dealings with most counterparties, the sale and the repurchase were separate arm's-length transactions. In its dealings with several other counterparty dealers, however, the advisor entered into prearranged sale and purchase agreements with dealers, which resulted in the selling fund securities to be repurchased by other funds at the bid price. More specifically, Western executed the sell side of the cross transactions at the highest current independent bid price available for the securities, and executed the repurchase side of the cross trade transactions at a small markup over the sales price. By cross-trading at the bid, rather than the average between the bid and the ask, the SEC found that Western favored buyers in the transactions over the sellers, even though both were advisory clients of Western and were owed the same fiduciary duty. By effecting these transactions at the bid or ask price, rather than the average of the two prices, the transactions were not in compliance with Rule 17a7's pricing requirements. Among its various findings, the SEC found that Western willfully aided and abetted and caused certain of its advisory clients to violate Sections 17a1 and 17a2. The SEC found that the transactions were not exempt by virtue of Rule 17a7 because the trades were not executed at a price equal to the average of the highest current independent bid to purchase that security and the lowest current independent offer to sell that security, and were made through one or more broker-dealers who received compensation in connection with the transactions. The SEC found that Western's cross-trading violations were caused in large part by its failure to adopt adequate policies and procedures to prevent unlawful cross-trading effectuated by its trading personnel, and by its failure reasonably to supervise a trader who aided and abetted the violations of Section 17a1 and 17a2. As a result of Western's conduct, Western was found to have willfully violated Section 2062 of the Advisors Act, which prohibits any investment advisor from engaging in any transaction, practice, or course of business which operates as a fraud or deceit upon any client. Specifically, in its dealer-interposed cross-transactions, Western favored certain of its clients and failed to seek to obtain best price and execution for certain of its clients in these cross-trades when it allocated the savings obtained in the cross-transactions to the buying client accounts in the transactions over the sellers. The SEC found that Western violated Section 2064 of the Advisors Act and Rule 2064-7, which requires that investment advisors adopt and implement written policies and procedures reasonably designed to prevent violations by the investment advisor and its supervised persons. The SEC found Western also violated Section 207 of the Advisors Act, which makes it unlawful for any person willfully to make any untrue statement of material fact in any registration application or report filed with the Commission, or willfully to omit to state in any such application or report any material fact which is required to be stated therein. Part 2 of Western's Form ADV filed with the Commission from 2007 to 2010 contained materially false statements regarding Western's cross-trading policies. Western entered into an offer of settlement with the SEC in which Western agreed to hire a compliance consultant to review whether its systems and controls are adequate to ensure Western's compliance with the cross-trading prohibitions of the 1940 Act, including its duty to obtain best execution for client transactions and its duty to treat all clients fairly. Western also enhanced its compliance monitoring of trading to identify potential cross-trades and revised its employee training to address the procedures and rules surrounding cross-trading. In addition, Western paid over $7 million to compensate its clients who were harmed by the improper cross-transactions. So what are the advisor's responsibilities with respect to Rule 17a7 transactions? As I mentioned earlier, consistent with the advisor's fiduciary duty of loyalty, an advisor should not cause funds to enter into a Rule 17a7 transaction unless the transaction would be in the best interest of both funds. The advisor must seek to obtain best execution for both its buying and selling clients. The duty to seek best execution means that if the advisor to the selling fund can obtain greater proceeds for that fund by selling the security in the market rather than selling it to an affiliated fund, the advisor has a duty to sell in the market. The same principle applies to the buying fund as well, and an advisor should not buy a security in a Rule 17a7 transaction that it could buy at a lower price in the market. Advisors must have policies and procedures reasonably designed to ensure compliance with the cross-trading prohibitions. So keep in mind that you must follow the advisor's policies as well as the trust policies. You must seek pre-clearance of the transaction by Marty. Please review the trust procedures so you are aware of the conditions set forth in that policy. The advisor must report the transactions to the Board of Trustees on a quarterly basis, and the advisor is required to maintain records of the transactions for a period of 6 years, with the first 2 years in an easily accessible place. That is, that it can be produced to the SEC within 24 hours. So what are the board's responsibilities in reviewing these transactions? Rule 17A7 requires a fund board to make a determination, no less frequently than quarterly, that each transaction made during the preceding quarter was effected in compliance with procedures reasonably designed to provide that the transactions comply with the requirements of Rule 17A7. The Commission, in adopting Rule 17A7, did not provide that a fund board's determinations could be delegated to another person. Fund boards may, where consistent with the prudent discharge of their fiduciary duties, make these determinations in reliance on summary quarterly reports of the transactions effected in reliance on Rule 17A7 during the prior quarter. Some fund boards may decide that it's necessary or appropriate to review each transaction in order to make the required determination. Other fund boards may decide to make the required determinations based on summary quarterly reports prepared by the fund's CCO or other designated persons. However, even if a board relies on the CCO or others to provide them with a summary quarterly report, the board still retains ultimate responsibility for making the quarterly determination. In addition, Rule 17A7 requires that a board satisfy the fund governance standards defined in the 1940 Act. The fund governance standards are listed on this slide, and they are that at least 75% of the directors of the fund must be not interested persons of the fund, that is, disinterested directors. The disinterested directors of the fund must select and nominate any other disinterested director of the fund. Any person who acts as legal counsel for the disinterested directors must be independent legal counsel. A disinterested director serves as the chairman of the board and presides over the meetings of the board. The board of directors evaluates at least once annually the performance of the board of directors and its committees. The disinterested directors must meet at least once quarterly at a session where no directors who are interested persons of the fund are present, and the disinterested directors have been authorized to hire employees or other advisors and experts as necessary to carry out their duties. The Board of Trustees of IMST and IMST2 meet these fund governance standards. Next, Joy is going to discuss some of the operational aspects related to the Trust 17A7 policy.
Thank you, Diane. That was a lot of good technical information. And now I'd like to spend a few moments discussing the reporting form for 17A7. Once you have pre-approval from Marty and you make a cross-trade, you need to complete the form. The form requires certification that you complied with the conditions of Rule 17A7. In the handouts, we have also provided a sample completed form. First, you need to provide basic information, the name of the buying account and the selling account. Obviously, one of these will be the fund in the trust. Next, you need to provide the security or securities that will be crossed. If you have more than one transaction, you can provide a table rather than having to complete separate forms. Other information required is the date and time of the transaction, number of shares or principal amount, and the price. I want to emphasize again that the seller and the buyer must pay the exact same price. Otherwise, it is a violation of the rule. After this information is completed, the form requires that you certify the following: that the transaction is a purchase or sale for no consideration other than cash payment. Another option that is seen from time to time is a consideration for securities, payments in kind, or other consideration as permitted by relevant no-action positions or exemptive relief granted by the SEC. For example, the Guidestone no-action letter permits unregistered funds to merge with registered funds, even if the cash condition is not met. In this consideration is for the new fund's shares. However, this situation only pertains to newly created funds that don't have any shareholders. You will also certify that the market price of the security was determined from one of the following independent sources: the last sale price or a NASDAQ official closing price. If there is no last sale price or NASDAQ official closing price, then the average of the highest bid and lowest offer should be used. For fixed income securities that do not have readily available market quotations, the evaluated price supplied by a pricing service can be used. This would be the price that the fund uses in calculating its daily NAV. For securities with no readily available market price or evaluated price from a pricing agent, then you must use the average of the highest bid and lowest offer by two independent sources. The details will need to be provided on the form. For example, if you called two brokers, you would provide the name, firm, time of call, etc. You will also need to certify that the cross-trade is consistent with the investment objectives and policies for both the seller and the buyer, the reasons for the purchase or sales, and that the proceeds and costs are the most favorable under the circumstances. I want to note that if you could get a higher price in the market for the seller rather than crossing, you should not cross the security. Same for the buyer. If you could buy the security for cheaper, then you should not cross the security. It must be in the best interest for both the seller and the buyer. Lastly, you need to certify that there was no broker commission fee paid, except a customary transfer fee, which Diane discussed earlier. Once you complete the form, it should be submitted to Marty and MFAC for review and sign-off. This completed form is the record of the transaction and will be provided to the Board of Trustees for consideration and ratification. I know that was a lot of information regarding Rule 17A7, and there are a number of questions coming in. We plan to get to these questions after the presentation. All right, now we're going to spend a few minutes talking about two other types of affiliated transactions, Rule 10F3 and 17E1. Rule 10F3 is when a fund has a purchase of a public offering where an affiliated broker-dealer is in the underwriting syndicate. Rule 17E1 is when a fund makes portfolio trades with an affiliated broker-dealer. These rules only apply if you have an affiliated broker-dealer. So, if your firm does not have an affiliated broker-dealer, then you do not have to worry about these transactions. But it's always good to know about these rules in case situations change in the future. First, I will discuss Rule 10F3, then Sarjona will talk about Rule 17E1. Although we don't see a lot of these, from time to time we have had Rule 10F3 transactions in the trust. The 40 Act prohibits a fund from purchasing a public offering when an affiliated broker-dealer is in the underwriting syndicate of that public offering. However, Rule 10F3 provides relief from the 40 Act under specific circumstances. I am going to spend some time to detail those specific circumstances. First, Rule 10F3 limits the type of securities to be purchased in the public offering. These are limited to 5 types. 1. Securities registered under the Securities Act. This is the main core category. Basically, securities that are registered with the SEC. 2. A comparable foreign offering. This means that the offering is subject to regulations of a foreign financial regulatory authority, similar to the SEC in the U.S. 3. Eligible government securities. These are securities issued or guaranteed by the United States. 4. Investment grade munis. These should have an investment grade rating from at least one nationally recognized statistical rating organization. And 5. Eligible 144A offerings. These securities must be able to rely and comply with Rule 144A. There are limits on timing and price of the purchase. The purchase must be made on the first day of the public offering. In addition, the price paid by the fund must not be more than the price paid by others. The next two conditions relate to the affiliated broker-dealer's arrangement in the syndicate for the public offering. First, the underwriting agreement with the affiliated broker-dealer must be a firm commitment arrangement. This means that the underwriters assume all inventory risk and purchase all securities directly from the issuer for sale to the public at a specified price. Second, the commission earned by the affiliated broker-dealer as a participant in the public offering syndicate must be reasonable and fair compared to similar offerings. It is important not to confuse this with the commission paid by the fund to purchase the offering. This condition refers to the payment earned by the affiliated broker-dealer. There is also a percentage limit on how much a fund may purchase. This is limited to 25% of the public offering, and it must be aggregated with any other funds you manage. And the next one is a big one. The public offering must be purchased from another broker-dealer in the syndicate, not from your affiliated broker-dealer. For example, let's say you are affiliated with JP Morgan. You may not purchase the public offering from JP Morgan. You must buy it from another broker-dealer that is unaffiliated. Lastly, the Board of Trustees will review and ratify any Rule 10f3 transactions. Then they will be reported to the SEC on Form NSAR. UMB Fund Services prepares and files this SEC form on behalf of the funds. The reporting responsibility for Rule 10f3 transactions start with advisors and sub-advisors. Advisors and sub-advisors are responsible for identifying their affiliated broker-dealers and monitoring for any transactions. You will need to complete the Rule 10f3 form from the Trust Compliance Manual and provide the completed form to MFAC in a timely manner, typically within 2 weeks. MFAC will use the completed form to ensure that the Board of Trustees has the necessary information to ratify the transactions and that it is filed with the SEC. For your reference, we have prepared a sample completed Rule 10f3 form in the handouts. Always remember that you are encouraged to call Marty or MFAC if you have any questions. Now, I will turn this over to Sarjono to talk about Rule 17E1.
Thank you, Joy. Thank you for providing the operational overview on 10F3 and 17A7. Now let's talk about Rule 17E1. 17E1 is transacting with an affiliated broker-dealer of the advisor or supervisor. If you do not have any affiliated broker-dealer, then this does not apply to you. If you place portfolio trades with your affiliated broker-dealer, you will need to make sure that the commission, fee, or other remuneration that is received by your affiliated broker-dealer should not exceed the usual and customary broker's commission. Under Rule 17E1, the most important is that the commission, fee, and other remuneration that is received by your affiliated broker-dealer should be reasonable and fair. Please note that you cannot engage in principal transaction with the funds under Rule 17E1. The reason is that it is not possible to determine best execution on principal trades, since the commission or fees are generally embedded in the price. Both IMST and IMST2 Trust have these 17E1 procedures in detail under Appendix I of the Trust Compliance Manual. I believe all of you should have a copy of these procedures. We would like to note that in the past years, we did not have any 17E1 transactions from any of our clients. All right, now, what are your responsibilities? If you plan to place portfolio trades with your affiliated broker-dealer on behalf of your funds, a few things must happen. You must contact Marty, the Trust Chief Compliance Officer, and provide the facts to him. Who is the affiliated broker, estimate of the compensation to be received by the broker, and a full description of the affiliation between the advisor and the broker. You can do all this in an email. You also need to perform best execution analysis and provide this analysis to Marty. Once you have received pre-approval from Marty, you must complete Rule 17E1 transaction form and email the completed form to him. Rule 17E1 transaction form is included in the Appendix I of the Trust Compliance Manual. For your reference, we have attached for you a sample completed form in the handout. From the Trust perspective, we will then report these transactions to the board at the next scheduled quarterly board meeting. So, we now have covered affiliated transactions under Rule 17A7, Rule 10F3, and Rule 17E1. As you are aware, questions related to 17A7, 10F3, and 17E1 are also included in the quarterly board book checklist that you receive on a quarterly basis, and it is attached in the handout for your reference. If you have any questions regarding this, please feel free to reach any one of us. This concludes our formal presentation, and we thank you for your time. We are now going to answer some questions that we have received.
Thanks, Sarge. All right, so now for the fun part. We're going to attempt to answer your questions. We want to thank you for participating in this webinar and also for asking great questions. If we are unable to get through all the questions due to timing, we will provide a summary of all the questions along with the answers at a later date. The first question is a general question. It is, will the slides be made available to participants after the call? Also, it would be very helpful to get them before the webinar in the future so they can be used for note-taking. I'll go ahead and answer that as well. And the answer is yes, the slides will definitely be made available after this webinar. And it's a great idea to provide the slides in advance. And so we appreciate that comment, and we'll definitely consider and try to make that happen for the next webinar. Okay, let's see. Here's another question for 17A7. As a mutual fund advisor, can or should I only do cross trades under Rule 17A7? Diane, you want to tackle that one?
Sure. The simple answer is yes. You should conduct cross trades under Rule 17A7 and the Trust Rule 17A7 procedures. But keep in mind, one of the conditions or considerations is that if the selling fund can get a better price in the market, then the fund should sell that security in the open market and instead of doing a cross trade. And also, conversely, the same for the buying fund. if it can get a better price in the market, it should not engage in the cross trade.
Right, right. That's exactly right. Thanks, Diane. We have a few more questions. Let's see. What are the significant reasons why an advisor would go through all the hassle, and I might add risk, of doing a 17A7 transaction?
Well, 17A7 saves transaction costs, and therefore it may be in the best interest of both sides if all the conditions are met. I'll just note in the Western case I discussed, by avoiding exposing the cross-traded securities to the market, Western saved market costs of approximately $12 million. So you can see how a cross-trade could be beneficial.
Right, right. Okay, all right. I'm going down the list here. Is there a reason why 17A7 transactions need pre-approval by the board versus 10F3 can be ratified after? I think I'll go ahead and tackle that, Diane, but feel free to chime in. I think first I'd like to clarify that the pre-approval for 17A7 is not by the board. The pre-approval is by the CCO. And I think that it is simply a matter of our trust compliance manual and the complexity of 17A7. So there isn't really any mandatory reason other than the fact that they're very sensitive transactions, and it's just part of our compliance policies and procedures. I think I'd also like to note that when we have had the 10F3 transactions, that the advisor did always contact us first, MFAC and Marty, just to make sure they were doing it right. So even though pre-approval is not required, everyone is always encouraged to call us and ask us questions to make sure that all the facts are being complied with. Let's see, here's a question for 17E1. What are the examples of principal trades under the 17E1 complex? Sarge, do you think you want to take that one?
Yeah, I'll try, Joy. Thank you. It's a good question. What are some examples of the principal trades under 17E1? Well, fixed income securities are generally principal trades, and then when you do principal trades, the commission, the broker commission, are often embedded in the price for the securities. And one of the conditions when you do 17E1 is that you need to perform the best execution. So under Rule 17E1, you can only engage in the agency trades because the agency trades breaks out the commission, which is easier to ensure the best execution. You want to add something else, Joy?
No, I think that's good. I think, yeah, I mean, principal trades typically have the commission embedded in the price, and in order to comply with 17E1, you have to have the commission broken out so we can show it to the Board of Trustees. We can confirm that it's for the best execution, and then the trustees can make their determination and ratification of those transactions. All right, and then, I mean, I think switching back to 17A7, which the majority of the questions coming in seem to pertain to, can the advisor override the pricing service price if the advisor believes it does not represent market price for the security being crossed? Diane?
Yeah, good question. But the answer is no. The market price for security must be made at the last sale price or the NASDAQ official closing price. This is a great example of what Section 17A is trying to prohibit, where an advisor could potentially overreach by assigning a value that they think for a security and either moving it or quote, dumping it into another affiliated fund. So That's a great question. I think that highlights why Section 17 and Rule 17A7 are designed to prohibit that kind of action happening.
Great. All right. Thanks, Diane. I think we have time for probably one more question. Maybe two. Give some examples of accounts that cannot cross-trade with a fund. Diane, I'm going to pass this one still to you.
Okay. Well, one example would be an account of a portfolio manager that cannot cross-trade with a fund, or generally anyone that is with the advisor or any account which the advisor or any of its affiliates own 5% or more would not be able to cross-trade with a fund.
Right. Okay, great. And I have one more last question because I think it's a good one. Are there any investments that cannot be cross-trades with a fund under 17A7?
Generally, derivatives, which are not considered securities under the 1940 Act, cannot be cross-traded. There might be some others, so that's why it's always good, under our procedures to seek pre-clearance and talk with Marty or MFAC to see if the trade is permissible.
Right, exactly. Great. All right. This seems like a good time to stop and let everyone get back to work. As I mentioned earlier, we will prepare a question and answer summary and email it out to everyone. Now I'll turn it back to Marty.
Thank you, Joy. I hope you found the information today pertaining to each of the rules 17A7, 10F3, and 17E1 helpful in understanding those questions when responding and completing the quarterly board book checklist each quarter. I would also like to thank our panelists today, Diane Drake, Joy Ostley, Giorgio Kidman, for joining our panel today. We will make the presentation available to you at some future date, as Joy responded to in the first question. If you have any additional questions on Rule 17A7, 10F3, or 17E1 going forward, please contact me or MFAC at any time. We'll be glad to respond to your questions. Thank you for joining us today, and we hope you join us on future webinars.